Good day, everyone. I want to welcome you for another exciting section. Today, we are going to talk about Adams versus Lindsell, 1818. I'm going to talk about the background to that case. The defendant sent a letter to the claimant offering to sell them a quantity of wool and asking for a reply by return of post. Unfortunately, the defendant wrote the wrong address on the envelope, so the letter arrived several days late. As soon as the claimant received the letter, they replied immediately by post accepting the offer. However, because the letter they replied immediately by post accepting the letter. However, because the defendant has been waiting longer than expected for a reply, they assumed the claimant were not interested and went ahead and sold the wool to someone else. When the claimant acceptance letter eventually arrived, the defendant claimed there was no longer a valid contract. The claimant disagreed and took the matter to court. Now let's talk about the significance of that case. This historic case gave us the famous Postal rule, one of the most tested rules in contract law. The rule states that when post is a reasonable means of communication, a contract is formed the moment the acceptance letter is posted, not when the other party received it. This protects the person accepting an offer. Even if the letter gets delayed or lost, the contract is already formed from the moment it enters the post box. This rule is still applied in Nigerian courts today. I want to thank you for being part of today's section. Don't forget to subscribe. Bye for now.